let's get started here. We can take our seats and get going. We have a very, very tight agenda today. Quite a bit going on. Okay. Good morning. My name is Jeff Applebaum, I'm Project Management Consultant. I'm serving as the owner's rep, project manager for the project. Welcome here. Welcome today to our steering committee meeting. You've seen on the agenda the purpose of the meeting. Basically, we're going to do a few things. We have some procedural matters to take care of initially. Then we're going to talk about the critical initial planning things that allow our group to go forward. Number one, we are going to talk ultimately about the size of a jail, whether new or renovated, the number of beds, and you'll start to hear about much more about what would be in a new or renovated jail.
Yeah, okay.
But we'll have a determination with respect to that. We will have a determination with respect to the initial vision of what is in the courts. In particular, the number of judicial officers and something about litigation spaces in the courts. And number three, as we have explained repeatedly, this is so dependent on right-sizing the jail, and it's so dependent on jail population, so we'll also have a determination about moving forward on the jail determination issues. So right now I'm going to start to call the meeting to order. We're going to go around quickly and do a roll call of our members of the steering committee. Just with name tags here, we'll start. And this is being recorded, and this is going to be online. I will also tell for everyone at the table, we do have microphones here. You can turn them on and off. So if you're having a sidebar, you might want to turn them off. But with green, they are on. And then ultimately, when we get into the audience, if there's public comment, we have a microphone. You have to be speaking into the microphone to be heard. So I'm going to also ask you to make sure, if you comment, to make sure you hand on the microphone, which we have for you. So at this point in time, we'll go around, we'll do our roll call, and just going around the table, and if you can just indicate your presence for the media. Mr. Stanton.
Mark Stanton, County Public Defender.
Mr. Schilling.
Dave Schilling, County Sheriff.
Mr. Budish. Mr. Gallagher.
Mike Gallagher, County Counsel.
Ms. Bird.
Ela Bird, Clerk of Courts, Cuyahoga County.
Ms. Black, who's the alternate for the county clerk.
Laura Black.
Mr. O'Malley.
Present.
Judge Russo.
Present.
And for Judge Sullivan, who I understand will be here in a while, Mr. Zach. Judge Early.
Present.
Mr. Kelly.
Here.
Ms. Langhenry.
Here.
And we are awaiting either Earl Turner or Kim Bates. Hopefully they'll show up, but they are not yet present here today. So just a little bit about housekeeping and protocol. We are going to go, this is going to be 4 hours, and it's going to be 4 hours kind of straight. We will take a break partway through. There is coffee out here and water, maybe an illicit treat, which violates our agreement with the convention center, but I don't know where they came from. And so we will be taking a break partway through. We will have, as I mentioned, opportunity for public comment. So if you're going to take advantage of public comment, there's a sign-in sheet up here. You must sign in. We will have a timer. It will be 3 minutes. We're going to divide the public comment into two segments. One set of public comment is going to deal with determinations number 1 and 2, which are the procedural matters. And then the second set of public comments will deal with the substantive matters, dealing with the courts, the jails, population, and also how we move forward on the population management issues. Just to very quickly take you through the agenda, and if anyone needs an agenda, we have some extra ones here. But the first two determinations will relate to whether we can amend the MOU, and we'll talk about that in a minute. And if the MOU is amended, whether or not the steering committee will admit a new member to the steering committee, which has been proposed by Judge Russo and Mr. Budish. We're then going to go through a summary of best practices. What we're going to do is start to talk about what's actually going to be the topic of the next meeting, which are best practices in court planning. We'll talk about best practices for jail planning and potential incorporation into programming. Now, we have been having working group meetings, and much of what we're talking about has been or will start to be addressed in the working group meetings, but this is sort of an overview for the steering committee as to what is being discussed. We will then get into the determinations. We will have our consulting team, our programming team, talk about the explanation and basis for determination number 3. We will then have questions from the steering committee, and we'll do the same thing for determinations 4 and 5. At that point in time, we'll take any public comment. I will then ask for a motion from the steering committee as to voting on these determinations. With any comment, keep in mind that at this stage, voting on these determinations will require a 10 of 12 vote, a supermajority, to move on. And we'll talk about the significance of the determinations and how they work. And then finally, we'll just have a few words about next steps at the conclusion of the meeting. So that is the agenda for the meeting. So at this point in time, we are going to, and I'm going to get the listing for public comment. So let me just say a word about the first 2 determinations. Determination number 1 has to do with amending the MOU to add a provision that actually permits amending the MOU. So the issue right now is the MOU, which is signed by 12 individuals, does not have a provision for amending it. I went to the individuals, the lawyers and others who were involved in the MOU, representing the various parties, and I put the proposition to them that they have to come up with these determinations. And the bottom line is that if you have an agreement or a contract to amend it, if the agreement or contract doesn't have a provision that says how to amend it, well, then the parties have to agree to the amendment. If you had a 2-party contract, each party would have to agree to amend it. If you had a 3-party contract, all 3 would have to agree. This is a 12-party contract, so all 12 would have to agree. Therefore, the first proposition that we put up is it's a determination by the steering committee, and since they're all signatories, they would all have to agree, which creates a little bit of an issue. By the way, if our 12th member doesn't show up, we'll have to figure out what we do about that. We may have to, well, we'll think about that in a minute. But that would be the first determination. The second determination then is if, in fact, the first determination passes, we then need, then it would be, okay, from now on, we will do this by a supermajority. So it would be like every other determination, 10 of 12 to make an amendment. So those are the issues on the table. And we'll see what we can do about our clerk, if we can, get someone here either for the clerk or to represent the clerk in this. Okay. Oh. Very good. Good. That solves one problem I don't have to think about. Okay. Okay. So with that in mind, I have a listing here of 3 individuals that want to publicly comment. We're going to have a timekeeper. Mike Wass is the timekeeper, 3 minutes, and he will also have a sheet that tells you when you have 1 minute left. So Ian Friedman.
Jeff, could I ask?
Yes.
Just number 1 is in drafting the MOU. This is number 1 is for the future of these discussions, because as we didn't contemplate this, there may be other opportunities that we didn't contemplate that this would play a part in. So it's a change for the whole future of this steering committee as we move forward.
Precisely. And there could be other issues that come up. That's a good point. As the judge points out, there could be other issues, and we wouldn't want to every time have to do this as a 2-part process. So the first vote is simply about how to amend the MOU, has nothing to do with the second vote, and that should be viewed independently. So with that in mind, Ian, can I get that microphone, please?
Mr. Applebaum?
Actually, Ian, do you want to, why don't you come up here? This is live.
We were not commenting on Proposition 1.
You can comment on 1 or 2 right now. I don't know if there's going to be a comment on 1, so let's just do the vote now.
Thank you.
Yeah, are you going to comment on it?
Thank you.
Go ahead, and your timekeepers is over there.
Thank you. Good morning, ladies and gentlemen. I'm Ian Friedman. I'm the president of the Cleveland Metropolitan Bar Association. I appreciate you having me and the other members of the Bar Association here. After I speak, I will be joined by Colleen Cotter, who is the executive director of Legal Aid Society of Cleveland, Gabrielle Kelly, who is a partner at Browse McDowell, and then Becky McMahon, the CEO of the Cleveland Metropolitan Bar Association. For this decision that we're here today to decide in this process, the Justice Center, we do understand and appreciate the gravity of this, and we do look at this as one of, if not the most important development to the justice system here in Northeast Ohio. I want to begin by talking about perhaps a misconception as to how the Cleveland Metropolitan Bar Association came to be and how this issue, this request to be part of the steering committee came to be. There was a belief that was shared with us recently that perhaps a letter was distributed to only some members of the steering committee requesting our appearance. There was not. There was a verbal request, and if you recall from the last meeting, myself and other representatives of the Bar Association appeared, just simply believing that this was a easy process and that we would be included in the steering committee. Such was not the case, and there was a dialogue thereafter after an objection was made. We appreciate the objection. We respect it. That makes for a good process. I will address the objections that have been shared with us to date by way of County Councilperson Michael Gallagher's letters. We do agree, sir, respectfully, with your contention in your August 14th letter that the Bar Association does have much to contribute to this process, and we thank you for that recognition. We do also take recognition of the fact that this should be a decision made by those who occupy and serve a critical role in the Justice Center. We believe that we do, as the lawyers, more than 5,000, almost 5,500 of us, plus our clients that are there almost on a daily basis. We do believe that we serve that. As to the duties and the fiduciary duties that you raised, we do have fiduciary duty roles. Lawyers to the court, the bar to our members and the community, the Bar Association to the legal community, the Bar Association to lawyers and the legal profession, and we do recognize the importance of the Justice Center to the profession. I'll wrap it up here very quickly. 3 minutes goes very fast. We would ask that all of you please look at and rely upon our letter that was signed by me, Becky McMahon, Rose Feeney, and Joe Gross, who will be the presidents who follow me, to talk about why we think that we will serve as a valued member of this and why we ask to be included. The letter, September 4th, Mr. Gallagher, that you submitted also takes exception to the contention that we claimed that there was a void. Thank you. May I just conclude my remarks?
You certainly may.
Thank you. Thank you. I would simply state that everyone here is valued and necessary. We believe that we bring the voice of the private bar, the civil bar, the voice of our clientele, and the voice of all of the non-lawyer citizens and other non-lawyer entities that we work with in this community. We will bring all of that to this. Lastly, before you, to address the concern that you had about conflict of interest, we did engage Jonathan Coughlin, who is the longest-standing disciplinary counsel for the state of Ohio. We supplied your letters and other material from this process. He had indicated, with all due respect, that there was not a conflict. So with that, I conclude. Thank you. I conclude simply by saying that we look forward to working with all of you in a process that that will ensure that the product that's given to the citizens of this county, and that really reflects to everyone who visits, is the top product, and that would be the product of all of your great minds, voices, and those of the CMBAs as well. Thank you.
Mr. Friedman, who was the request made to participate in this process?
The question is, who was the original request made to? I had a discussion with our administrative judge, John Russo, originally, and that's where that began. There was no documentation thereafter.
Thank you.
And there was not a need to field to the sheriff? I read from your letter that you believed that there was going to be a vote last month.
We did, that's correct.
Who led you to believe that?
In the discussions that we had, myself and Judge Russo, it was our understanding that we were to appear that day and that an amendment would be made to the MOU that day,
How did you come to that understanding?
based upon what the discussion that was had between Judge Russo.
Yourself and Judge Russo made a determination that this committee, composed of 12 members, would have a vote for your participation in the committee without any knowledge or any earlier discussion with the body as a whole?
So it was, the question being whether or not there was an assumption made that there was a decision made without discussion with the body whole. Is that fair?
Yeah.
All right. So the response to that is, my discussions were had directly with the judge. Becky McMahon, our CEO, had been in discussions with others. She can discuss that when she takes the podium in a moment. And I will say this, the determination was not anything other than we had voiced our concern again, and our understanding was that the discussion was had with the judge, with our county executive, Armin Budish, and that we were to come that day. As for what happened behind the scene, Prosecutor O'Malley, I cannot answer that. I was not behind the scene.
I can just say this. This county deserves better than behind the scenes.
I agree.
The members of this committee deserve better behind the scenes. I knew nothing of this proposal to the minute I walked into the last meeting, and I know I'm not alone.
And that's, go ahead.
And I just think that, especially in all public bodies, and this is a public body, that we deserve better, the citizens of this county deserve better. And I'm not opposed to the concept of discussing this, and there may be further discussions with other entities in the future. But what goes on in this meeting has to go on in this meeting, and it needs to be completely available to the public. And behind the scenes chatter as to adding people, this MOU took us months to craft. And to think that some people were not brought into that discussion when there was a belief that we would be voting to amendment is offensive to me.
Well, I got to respond because all that happened, Prosecutor O'Malley, is I spoke to the executive and it was added to the agenda as a discussion piece. It wasn't a vote. I asked Mr. Applebaum, and it's on, if you go to the agenda for the last meeting, it says discussion. So that was it. There was nothing other than that.
Judge?
There was no vote.
I think I have the floor.
I need to respond because you're being accusatory of me.
You'll have your minute. But all I'm suggesting is these public discussions need to be public. And obviously, as Mr. Friedman has indicated in his letter, that he was under the understanding that there was a vote going to be taking place. And I'm certainly, and I've had discussions with Mr. Friedman, I was, after we sat down, I voiced what my objections to his participation is, but I just think, and I would say them publicly, I think there's issues with the judge yourself situation. We've had a discussion on that, but I think that when we're going to have such a significant event to amend an MOU that took months and months to get complete consensus on, that we need to all be brought to the table.
Prosecutor O'Malley, would it be helpful, would you feel it necessary for me to, and I'm perfectly comfortable doing that, discussing all of the conversations I've had with members of the steering committee since the time of the last meeting, including the conversation you and I have had leading up to this point for purposes of transparency?
If that's the desire of the committee, I just want to let it be known that I thought it was, and I was further educated when the letters started coming out indicating that there was a belief that there was a vote to be had. And again, I just think we all need to be brought to the table on those, especially an issue such as that.
So I'll simply say that if you don't want me to, I certainly don't feel the need to get into every conversation we've had since then, but I'll simply say this. Whatever happened with the process is fine, but the big picture here as to how this county can best be served, we now have had time since the last meeting until now to put that in order. We believe that the CMBA's voice, the voice of Northeast Ohio's legal community, can certainly assist. And if there are any further questions here in the open, I'm more than happy to answer all of those if you'd like. So I stand here ready to answer any questions.
I let my thoughts be known.
Very good. Thank you. Any other questions?
Judge, did...
Well, we thank you for your efforts.
Mr.
Yes, sir.
Freeman, I want to thank you for the discussions that we had. You called me, I called you.
Yes, sir.
And I expressed my concerns, and going back to what Mr. O'Malley's saying, the thing that really kind of grabbed me was the fact that it was stated that you were blocked from a vote. There was no such thing that happened, because there was no vote. And that's where we're going here. Members of the committee, this is a very delicate time. This is exactly how we got the Juvenile Justice Center in the middle of nowhere and over budget and past time. We have a committee, we have a group. It took a year to put this together. I don't discount the valuable need of having a voice from the legal community, but the reality is, and could I have a show of hands of who's a member of the Cleveland Bar Association on the committee? Nobody?
I should be.
I am.
Okay. So there is more of a voice on this committee of the Cleveland Bar Association than the county council, the county executive, anybody else. You're well represented, and that's going to be the stance of the council. The committee, be clear. This is an open process. The reason it's being streamed is because we wanted it streamed on the council. The reason it's archived is because we, the council, wanted it archived. And the reason we wanted this is for situations like this, because historically, people are going to look back and find out where the problems were and who did what, who said what, and how you voted. You can't find any of that on the Juvenile Justice Center. I said it before, they blame the guy that died. God forbid 12 of us died, but we're going to be historical here in what we do. So being clear and being in the open, I don't think anybody's being accusatory here, but this was quite a surprise to, if not all of us, many of us. Sure. So I'm sorry how it unfolded, but I greatly appreciate our discussions.
And Mr. Gallagher, I want to thank you as well. We spoke at length. You called me back as quickly as you said, and we've addressed a lot of different points. So I do also appreciate that. And clearly, while we may disagree on certain points, we agree on the importance of this project and the need for it to be perfect. And so I recognize you for that. Let me just simply say that I don't respectfully agree that because there are members who sit here that are members of the bar, that that's adequate. And I say that for this reason. Those that sit here who happen to be members of the bar, first off, that would be addressed in Jonathan Hoagland's letter, but they also have other considerations. For instance, our public defender has the interests of the public defender's office. We have interests of the clerk of courts. We have interests of the judges. The Bar Association comes in clean with only the interest of the legal community. We don't have any split considerations at all, and that's where I think that there is a difference that can be met. I simply respond to you finally with saying that there may have been plenty of surprises with you and others, with us. But we have the opportunity now to call that yesterday, look at today and forward, keep in front of us what's most important. And again, that's making sure that we don't have a repeat of history, that we can build a product that we can all be proud of, and the CMBA can help to deliver that. And so I thank you.
Thank you. I'm going to move on.
Well, I don't know if you can move on. Well, I just have, I think the comments were made, and I don't know if this is on because I don't know if I could hear myself, but it is a public meeting, and I forget sometimes that we're playing to that as well, so maybe some of those comments are played. This was part of the agenda for the 12 members in this room on August 7th. It was listed as a proposal, and that discussion was had openly with all of us, and we tabled it. All of us decided that. That was a discussion that was emailed to all of you before the meeting. So don't play to the public that there's something going on behind the scenes, because that would be wrong. Totally wrong. And when the discussion was had, there was discussions privately with the prosecutor. I've had those discussions with you and others. So this was not a surprise, and I don't want the public to think that Judge Russo secretly put this on for a vote. We discussed it, it was on the agenda, and all of us rightfully tabled it so that we could have further discussions, and I commend all of us for doing that. But in no way was this done behind the scenes. Of course there was a discussion. That discussion, actually, Mr. Applebaum, went from you to me to the executive to please put it on the agenda. Thank you.
So, and I'm going to ask you because...
Thank you for your consideration.
Because my effectiveness of managing what is supposed to be a public comment section has been completely blown, but that's okay. We got important discussions out. I do want to point out, with no comment, what did occur was the request was made to put it on the agenda. And by the way, another interesting thing about the MOU, I am supposed to, with my team, manage the substantive part of the agenda. There is no process for putting procedural matters on the agenda. There just isn't. So what we simply said was, but what I did point out to everybody was, even for that, if it's a determination, it would have required advance notice. We didn't have it, so we said it's a discussion item. We made it a discussion item. And then after that, I turned to the lawyers to say, how do you want to propose to do the MOU? So that's what occurred, for what it's worth. So what we're going to do is I want to get through the rest of the public comment, and I put down my sheet. The second individual on this topic is Colleen. And by the way, when you give a comment, please indicate your name and who you are, so because it's on the record, as Mr. O'Malley's pointed out.
Thank you. Thank you and good morning. My name is Colleen Cotter. I'm the Executive Director of the Legal Aid Society of Cleveland, and I'm also proud to be a member of the Board of Directors of the Cleveland Metropolitan Bar Association. And I'm here to encourage you to allow the Cleveland Metropolitan Bar Association to become part of this body. As we've talked about already this morning, this is a huge decision for our community. This is a once-in-a-century decision in our community about justice. And so that's my perspective in talking to you here today, is the focus on justice. Because I really believe that where justice is delivered, the setting in which it is delivered, makes a huge difference to our community. It's what I've done with my whole career, is bringing justice to our community in my way. And everyone here is part of that process in figuring out how do we and where do we have our new justice center and jail. And that sounds so dramatic. This is all about justice, but I truly, truly believe that. And I also believe that in order to have a truly just society, we have to embrace diversity and we have to embrace inclusion. And part of that is to bring to the table a wide variety of perspectives so that we can have true engagement, put all of those perspectives into the crucible of tough conversation, and out of that, create a good decision for the community. And as I said, I'm a member of the Board of Directors of the Cleveland Metropolitan Bar Association. I'm the Executive Director of Legal Aid. We represent people in poverty. And the CMBA has, as part of its code of regulations, that I get to sit on the board and have been a board leader for a number of years. I'm part of those daily conversations about how we, as the Bar Association, can help create a more inclusive, more just society from the perspective of the bar. And I sit with my colleagues who are from large firms and small firms and solo practitioners and government attorneys, and together we talk about how can we create a more just community. So bringing that perspective to this deliberation, to me, makes a ton of sense. I have no idea about the process, how this all came to be, how this membership was created in the first place. So I'm new to this conversation, absolutely, but I believe strongly that you all will benefit from the presence of the CMBA. Not only is it a diverse group of bar members, but we all have diverse clients. from large firms that represent corporations to the Legal Aid Society, who represents those struggling families who are faced with, do I go to work today or do I show up in court? I have a summons, and how they get through that process. So having that voice at the table all through the Cleveland Metropolitan Bar Association, I really believe that you all will make a better decision for that inclusion. So thank you for your time. Thank you for your service. I know this is a huge commitment by all of you to this process, so I want to thank you for that on behalf of Legal Aid. Thank you.
Thank you very much. Gabriel Kelly.
Good morning. My name is Gabrielle Kelly, and I'm at Ross McDowell, but I am also a board member with the Cleveland Metropolitan Bar Association. I am the vice chair of the Diversity and Inclusion Committee of the Bar Association, as well as the former chair of many sections and committees at the bar. And I just want to provide a couple of comments in support of the CMBA being added to the steering committee here. The CMBA provides perspective that isn't just fully captured through civic engagement and voting. Although the CMBA is a group of lawyers, those group of lawyers, as diverse as they are, spend time every day in the Justice Center. And it's not just the CMBA. Through its partnership with other bars in the city, bars of color, other special interest, if you will, bars, they have an obligation to listen to those bars, listen to those members, and to advocate for what those lawyers and those clients are seeking as well. And the CMBA takes that position and their duties to those other bars and their clients very seriously. And it intends to bring all of that background to the steering committee if added as a representative. The CMBA isn't just a place for lawyers to gather after work at the law firm. Through collaborations with the law school locally here in town, as well as through its pipeline programs, it represents our future lawyers, the future people who will be serving in the Justice Center or whatever new entity shall exist. And the CMBA, in a way that isn't necessarily just captured by individuals voting on representatives, it has that voice, and it will speak for those individuals as well. And so in thinking about whether to add the CMBA to your committee, consider that although there are many lawyers who are distinguished and will more than likely take their role as a CMBA member into consideration, they don't have their pulse on all of these different areas like the CMBA does. And we just add that you consider adding that voice as one of many here to your committee. Thank you.
Thank you. Rebecca McMahon.
Good morning, and thank you for the opportunity. My name is Becky Rupert McMahon. I am the CEO of the Cleveland Metropolitan Bar Association and Bar Foundation. I appreciate the chance to be heard. I joined the Bar Association staff about 5 years ago as the chief executive after spending 20 years practicing law, 15 of which were as a civil litigator in different courts here in this community. Mr. O'Malley, let me go directly to your comments. I began the conversation about the Bar Association coming in. When the announcement came out as to who was on the steering committee, we lauded the impressive lineup of individuals who are in this room. There's no question you all bring a critical perspective. But I was stunned to see the absence of the private bar in this steering committee. I began the conversations. Before Ian Friedman became our president in June, I began the conversation, and I intentionally did not want to do a behind-the-scenes, closed-door lobbying effort. And instead, I went to the individual that I understood had been designated as the project manager for this group, and that's Jeff Applebaum. Jeff and I knew each other from years ago when I was a deputy general counsel at Key Bank for 10 years, and so I reached out to Jeff to begin the process end of March, beginning of April, to say, how do we get in the room? How do we begin the process of being in the, I didn't want to do an individual reach out. We wanted a collective. And so we were led by the guidance of Mr. Applebaum. I can't comment on the process, but I can tell you that our commitment and our capacity to serve and to be in the room and help assist in making these critical decisions is as genuine as any of your individual views. I came to the CMBA as the Chief Executive Officer because I jumped at the chance to lead an organization where our mission is to promote the rule of law and to improve the quality of and the public trust in the administration of our justice system. At the core, the Cleveland Metropolitan Bar Association calls on those of us who work in and around the legal system in our community to play proactive roles in our professional development, in the development of others, in lifting up those in need, and in community programs. But perhaps most importantly, we serve as an organization that demands that our legal system be open and fair for all, without regard to race, to social status, to financial capacity, or family lineage, or even back office access. Inside the CMBA, we listen and we learn from one another. We share best practices. We challenge poor practices, and we collaborate on solutions. We strive every day to speak with one another with civility and genuine integrity. The steering committee is impressive, but again, I will say to you, there is a glaring mistake in the absence of the private bar. This would be like building a new medical system and saying to the family practitioners, the OBGYNs, the pediatricians, don't worry, the surgeons have your best interests. The cardiologists can speak for you. Just like the medical profession, this community needs to speak with the whole body when we talk about the justice system for all. When these discussions began years ago about whether to build or rebuild the Justice Center, the attention was focused on the physical building. Clearly, you all know it is more than just a physical building. It is a system of justice, and the CMBA ought to be here at this table helping you build the best system that our citizens deserve. Thank you.
Thank you. And I do want to make it clear, at the time, Ms. McMahon did come to me. Actually, she sat next to me at the grand assize of Nicey Prius, which is an awkward place to begin a conversation. I did then point out to her that I have no power to put anybody on the steering committee. I explained what the steering committee was, what the process was, who the members were, and that for that determination to be made, it would have to be made in some process with the steering committee. And I believe it was at that point in time, learning who the steering committee members were, that you reached out to Judge Russo. I want to make it clear that as anybody would, I would explain what the steering committee is and how the process works. So, in any event, that is the background. I think that's the request. So we have two determinations. The first determination has nothing to do with the bar specifically. As I think Judge Russo pointed out, it is simply a method to amend the MOU if we have further issues for amendment. So it reads, the steering committee unanimously agrees to amend the memorandum of understanding regarding the new Justice Center project MOU to add a provision providing for a supermajority vote to amend the MOU going forward. So before I make a motion, is there any further discussion? Now this is limited to the steering committee members. Any further discussion on this proposition before I ask for a motion? Yes, Mr. Stanton.
Thank you for recognizing me. Mr. Applebaum, the vote on determination number 1, does that include discussion as to whether or not other entities should be involved at this time? Because once we start down that road, there's a hell of a lot of houses that are lined up on both sides of the street that could be included in that neighborhood.
Yeah, I would say determination number 1 speaks for itself.
Okay.
All it says is that in the future, you would talk about, if you want to amend it, it's the supermajority.
How imminent is the future, though? That's my point.
It starts, we're there. This is your discussion. Thank you. Any other, by the way, Mr. Stanton, I have to point out, every comment you've ever made always ends with a question. I love that. That's very good. It's always a question. Any other comment from the steering committee on this issue? Okay. Is there a motion by the steering committee to vote on determination number 1? Judge Russo makes the motion. Is it seconded, just for the vote? We have a second from Judge Celebrezzi. Now, at this point in time, what we're going to do is we will vote, and we will record the vote. I do have one thing to do before we do that. We had one member of the steering committee that came a little later. Could you please indicate who you are and who you're here for?
My name is Kim Bates, and I am here for Earl Turner, who is the clerk of Cleveland Municipal Court.
Okay, and you are the designated alternate. So now we have all of our members of the committee. All right, so now this is a determination, and what we will do is, by the way, I will also tell you that we do not have this is our first determination that we're going to vote on. We do not have a specific determination, a specific process for voting, but I will tell you, and let me mention this, my view is on any determination, obviously it's an open vote, not a closed vote. People have to indicate where they stand. And I will simply ask one question of you as a committee. We can do this in one of two ways. I can ask for hands, and or I can go around the room. The normal method is to call the roll and go around the room. Is there any objection to doing that?
No.
Excuse me?
Because of the recording, you should call.
Well, yeah, well, I would also then call out the votes, but I just want to point out, I'm going to go around the room in this direction. And the next determination, I'm going to go this direction, and the next one this direction, all right, because it's scientific. Okay, so let's begin. On proposition determination number 1, Mr. Stanton, your vote.
I agree to amend.
You agree to amend. Mr. Schilling, your vote.
I agree.
Mr. Budish, your vote.
Yes.
Yes. Mr. Gallagher, your vote.
No.
No. Ms. Byrd, your vote.
Yes.
Ms. Black, your vote.
Ms. Black was not.
I'm sorry, that is your vote. I'm looking at the sides. I know you vote. Mr. O'Malley, your vote.
Yes.
Yes. Mr. Russo, your vote.
Yes.
Ms. Celebrezzi, your vote.
Yes.
Judge Early, your vote.
Yes.
Yes. Mr. Kelly, your vote. Ms. Langren, your vote.
Yes.
Yes. And Ms. Bates, your vote.
Yes.
Okay. By 11 to the vote, however, is not unanimous. Therefore, on determination number 1, we do not have a unanimous vote. At this point, we cannot amend the MOU. That means that we do not have and let me just ask you, is there any, I say further discussion, but I think we've had that discussion. There can be no vote on determination number 2 because it required a unanimous vote on number 1 for the steering committee to vote on number 2. Okay. So we have concluded that piece of procedural business. I will make one point that I would like to make personally to the bar. One of the roles I have is stakeholder outreach. The bar is an extremely important member of our group, and by the bar I'm talking about lawyers. We have working groups. We have proposed, our committee wants to hear from the bar, wants to engage with the bar. We propose to set up a working group which is with the bar. We will give you access to our consultants. We will have special meetings with our consultants. We will get your input to our consultants, and we will report what we hear from your consultants. I know this is not the result you were looking for today, but I encourage the bar not to turn their back on this process. I know you won't. You're very critical to this, and I would like to make sure that we have further stakeholder engagement at the bar level. Now we're going to move forward at this point in time. We have gone through the agenda. And what we're now going to do is we're going to go to issue to number 8. We're now going to start going through the summary overview of best practices for court planning for potential incorporation in programming. And I'm going to turn this over to Dan. Or I'm going to turn it over to Andy first. I'm sorry. Andy first.
Thanks, Jeff. Here, Dan, you'll be next.
I appreciate the opportunity today to be here again. We have three important determinations coming up related to the size of planning for the courthouse and the jail. We've already started to engage working groups, though, in what the real mission here, which is about how we create facilities for the future that are more effective, that are more efficient, that solve a lot of the issues you all have been dealing with. We've had two-hour meetings with the working group. The court's working group was well represented. Dan's going to give you just a brief overview of what we did in those 2 hours, all looking to the future, about what the future can be. We also just yesterday had a 2-hour meeting with the jail working group. The purpose of this is to start to investigate best practices so that once we make the determinations of what the basis is for planning moving forward, we are looking beyond what we do today. So Dan's going to give us just a brief 15-minute overview of the best practice workshop on the court side, and then we'll give an overview of the workshop on the jail side.
Thank you, Andy. Good morning, everyone. Can you all hear me? All right in the back? Yes? Okay. The working group for courts met last Tuesday. As Andy has mentioned, it was very well attended. We had presiding judges, we had high court officials from all of the courts. We had representatives, we had the clerk of courts, we had representatives from the municipal court clerk, the county prosecutor was there, the public defender was there, and we appreciate all of their participation and their input throughout the meeting. The meeting was conducted in two broad sections, the first being an open discussion on a variety of topics, which I will use the second section to summarize. The second part of the meeting was a series of slides that we showed that were used to develop additional discussion and to start the ball rolling on the overall programming process. I have to remember which one of these buttons to push. Okay, there we go. I think it's important to recognize, first of all, that this was not a meeting about decisions. This was a meeting about discussion. And the discussion ranged widely and covered a lot of topics, and I've tried to combine them into a set of cogent categories here that I hope will serve to reflect what actually happened in the meeting. The first category is security organization. I think we all agreed that security is a very, very important part of contemporary courthouse planning. The diagrams you see before you reflect some of the issues in circulation, the separation of circulation. The pictures reflect the way in which we might provide separate witness waiting under certain circumstances. The point is that in the context of contemporary society, it's very, very important for us to plan a courthouse that is secure. One of the strange facts of life here is that even as we promote security in courthouses, we're also promoting accessibility. And sometimes those are uncomfortable partners. But we have to plan for both, and you can see some of the things that we're discussing as we go forward. Our second category was what I've called technological integration. Technology is now an absolute part of our lives. I see cell phones all over the room today. Forgive me, I don't do my notes on my iPad. I haven't quite gotten that far yet, but we all recognize that technology needs to be infused into the very fiber of the building. It's not just about the building, though. It's about the processes. So many of our processes are being converted to technological applications. And these have another very, very beneficial effect in that they promote efficiency, in that they promote public access. And so we want our planning as we go forward to completely embrace the technological revolution and to be sure that the technology is fully integrated into the facility and into our operations. The third category was service orientation. The primary purpose of courts, as you know, is to do justice and to resolve disputes. That adjudicatory role is crucial, but what has been happening in courts around the country is that there's been an ever wider embrace of service delivery. Your domestic relations court and your housing court, and frankly, all of your courts have a number of service provisions. Those programs are important. They help resolve cases. They help people come to terms with, to resolve their disputes. And so as we plan this space, we want to be mindful not just of the adjudication process, but of the service delivery process as well. There are impacts that these services can have on the way spaces are arranged and on the nature of the spaces as they're put together. Our fourth category I've characterized as operational exploration. And there are several items here. Now, as I told you before, our focus is not on resolving everything right at this exact moment, but to set the stage for ongoing discussions about a wide range of issues. One of them here is this whole question of the range of courtroom sizes and configurations. All courtrooms are not created equal. Every single person does not require every litigation a full-scale jury courtroom. But we need to have the discussion. We need to talk about the varieties of litigation. We need to talk about special circumstances. We need to talk about the usefulness of particular spaces to particular kinds of proceedings. And as we go forward, we're going to use that now to craft what I hope will be a very, very efficient and useful way of accommodating the crucial functions that we face. The second category here, we'll talk more about litigation spaces a little further on in the program. Early disposition courts. The discussion here was not so much about early disposition courts that frankly, I thought got a great reception. It was about the opportunity really to develop litigation, early disposition court module that would bring together the pieces parts that really make that process work. There were examples given from other jurisdictions, and I thought there was a pretty good discussion about the applicability here and how that might benefit the system going forward. We talked about pretrial services. There are going to be a good bit more about pretrial services in the description of the best practices on the jail side, but pretrial services are sort of a critical ingredient these days and really helps to create a flow-driven process that brings together a variety of players and produces an early intervention in the system that can benefit expedited case processing and can benefit jail population as well. There is a question of, yes, sir.
What we'll talk about in a moment about how we do intake, there was a lot of broad-based support for the fact that we can look at doing things differently. Mr. O'Malley talked about potentially looking at 24-hour charging units, which can have an impact on our jail population. Court Services talked about expanded pretrial screening at intake and determining at intake if somebody needed to go to a specialty court. The reason I emphasize those is because those are the other side of the equation, that while we're looking at a building, there's also operational issues that will have to be addressed and considered as part of that planning process.
Continuing on, we have shared resources. This kind of a project gives us a great opportunity to focus on the shared resources. Many of these are self-evident, I know, but as we go through this, the pretrial screening, the jury assembly, the interpreters reporting, we actually called these opportunities from the group as we talked together. And I thought it was very constructive and very helpful and tells you a good bit about how well the system can work together to provide the services that people need. And finally, just a quick touch on the issue of defendant management. Andy, want to click the slide, please? Andy, there you go. Thank you.
My fault.
Little sidebar going on there. Listen, one of the things that was mentioned early on in the process was attention to some of the conditions in the existing facility that impact the court's ability to do its job effectively and efficiently. And so I just wanted to recognize the fact that we had a discussion about how best to manage defendants. to create an opportunity for attorneys to actually meet with their clients in better circumstances than are the case at this point. We talked about the amount of holding that might be necessary between pairs of courtrooms in criminal cases. And really talked a good bit, I think, about attorney access to the defendants, both at the court level and at the jail. So these important aspects of defendant management were mentioned and discussed, and I think in total, these matters really begin to set the stage now for the programming process that we hope to enter into. Actually, we're already even started entering into it to develop a space program that really reflects good operational practices and reflects the best of court programming and design practices as well. I'd invite any member of the working group that was present at the meeting to add anything to this. Anything from the prosecutor, from the clerk, from Stanton? Did I summarize it reasonably well? I'm seeing heads nod. Yes. All right. Well, thank you very much for the opportunity to work with you on this, and we'll look forward to continuing the dialogue and continuing the discussions to create a even better system.
Thank you.
We're now going to move on and talk about best practices for jail planning, for potential incorporation and programming. Andy Couples is going to begin this conversation. I want to point out once again, these are programming concepts for incorporation. They do not suggest yet the final solution. They don't tell you whether it's a renovation or a new build, but these are concepts that would be involved, we believe, to some degree, in any planning process.
Picking up what Jeff said, the whole purpose of this exercise is to say, here's things that are being done elsewhere. Yes, now it is. The whole purpose of these meetings was to have a discussion about other ideas, things that are being done, things that can increase efficiency, things that can increase effectiveness, things that can solve a lot of the problems Cuyahoga County's been dealing with from a facilities perspective. Not going to work today? There we go. So this is a range of ideas we went through over a 2-hour process. The other purpose of this is we develop programs for both the courthouse and the jail. Eventually we'll come to a point where these are things we do want to do, and we do plan to take visits to go see facilities so that people can work in the courts or work in the jail, work in can talk to their peers about how well it works. So we looked at housing, intake, special needs, facility zoning, a whole range of services over 2 hours. And probably the biggest issue of focus on was housing, because housing represents 60% of the area of the building that we'll be developing and over 70% of the staff. And in many ways, some of the things we've seen in the existing facility are a lot of the things that are driving operations and driving the issues that the county's been dealing with. So if we take a look at the existing jail, Jail 1 has a capacity of about 1,300 beds. One of the critical issues is that most of the general population is in very, very small housing units, which drives staffing, which drives operations, and as we discussed yesterday, I have to staff housing 24/7. So when I do have a shortage of staff, programs get hurt, movement to courts get hurt, ability to go to recreation, a lot of things get cut back on because I have to staff housing. The other issue is there's limited program space on the floor. Jail 1 requires movement for everything. Typically today, as we'll talk to just share with you, jails are planned with services at the housing unit. The reason being is I'm staffing that position for safety and security. Why not also have that same person deliver programs so that I don't have to have extra people to move my offender population to recreation, to medical, to mental health? There's no real outdoor access. Basically, we have gymnasiums with louvers. People never feel the sun on their body. It's an issue of wellness. And there's no real natural light in the day rooms. And if you think about basic human rhythms, if you live under fluorescent lights all day, staff as well as offenders, it affects you psychologically. Jail 2 has a capacity of about 1,131 beds. Again, in small units. There is program space on the floor, but not at the housing unit. It still requires me to take folks out of a housing unit to go to programs and services. One of the most critical issues we'll talk about in programming is how big should a housing unit be, because that, as I said, that affects typically 70% of the staffing needs for a jail. So what we really talked about was moving towards full direct supervision. You know, right now you do have staff assigned to every housing unit, but many times they're in the vestibule area. Folks are locked in their rooms. Full direct supervision means we're like we are in this meeting room. We have the ability to communicate. We have the ability to manage the population. It really does rely on direct interpersonal relationships as a management strategy.
Andy, would you, one favor, just because not everybody in the room that knows this concept, would you go back to your slide of Jail 1? Explain with this setup how direct supervision works here. How it has to work here.
Basically, these are small housing units. They were originally designed as 24 cells. This was the vestibule area, and currently in most of these units we have a staff desk in what was the vestibule area. Direct supervision, as you'll see from a couple other illustrations, puts that desk out here, puts that person right in the middle of housing, part of managing that population. Fair?
The point, though, is that with direct supervision, the best you can do, no matter where you are, is this unit.
Yeah.
So every one of these units has to have their own personnel or own direct supervision, no matter which.
Yeah. So basically, you're driven by the fact that they were built as 24 cells. You've added a few beds by converting some space. So your ratio is 1 to 24 to 25. So,
I just want to add one more. Is that not working? It's not working. I just want to add one more thing with clarification while we're on the slide. The actual rated capacity of Jail 1 and Jail 2 is far less than these numbers.
These are the numbers if you stuff all the cells, which is what you've been operating over capacity. This is not the official rated capacity, which is, I believe, Rhonda, 1,765.
1,700 for the system.
So just see for clarification.
Yeah. I would really refer to bullet 3 on here. So we've been through 2 or 3 of these slides with a group. The bottom line is what we're discussing with the staff, with the jail, with the county, is an operational system that's been proven to reduce homicides, suicides, sexual assaults, and incidents in the jail, because it relies on direct management and knowing what's going on. And that is, to a large extent, affected by your facility. One of the things we talked to the jail about that they've already started is objective classification, which means everybody that comes in will be assessed. What kind of risk are you in terms of a public risk? What kind of risk are you in terms of an institutional risk, as well as mental health issues, potential suicide and depression issues, and other kinds of things. And this is just a discussion of how important that's going to be for the future. And of course, I can't get it to work.
Well, it's more than just direct and indirect supervision. It's an issue of when you're starting to look at the design of the facility conceptually, it's the only time that profiling is appropriate.
I'll get it next time.
Okay.
And you have to profile the
You should just have to
population.
click the button.
So once you look at those percentages, you then look at what is the best way to house, what's the best way to supervise, and what's the best way to deliver care services to each of those categories of population. So hence then goes the design of the facility.
So to a large extent today, what we're doing is driven by the facility we have. As we look to the future, we want to base it on the population we're serving and how we can best house them.
Well, it's more than just
One more.
direct and indirect supervision. It's an issue of
So this is what service delivery at the housing unit means. If you look at your current housing, as we showed on the slide, it's basically cells and an officer station. That's all that exists in a housing unit. Service delivery at the housing means that we have commissary and medical kiosks, so offenders can actually schedule visits. They can schedule commissary, they can schedule library, they can request mental health or medical treatment. We have decentralized programming. Right now, if somebody needs to see mental health professionals, we're moving them from housing to mental health. If we don't have the staff to move it, an appointment's missed. It's inefficient for both the jail, it doesn't service the offender, and it's inefficient for medical mental health services. By putting those kinds of interview rooms and space right at housing, we're moving people through the jail that can move by themselves. The mental health professionals can go from an office to a housing unit to deliver services. Recreation at every housing unit. The ability, as you'll see in a couple examples, to have connected to that housing unit an outdoor recreation area. So that instead of moving people for recreation and saying your recreation area is from 9 o'clock to 10 o'clock on Tuesday, it's simply available. So that there's more access to program, it's a better environment, and it's been proven, as a couple of the slides said, to reduce violence, to reduce incidents, to calm the atmosphere for how the jail operates. Dining on the unit, medical triage on the unit, medical sick call comes to the unit. We don't have to move everybody to the clinic. Those are the things we're looking at as best practices. And these are some examples of what a modern housing unit can look like. Softer furniture, groupings of furniture. We can actually use the day room for program delivery. This is a critical issue that Curtis and his team and myself will be dealing with the jail as to what should a housing unit size be. Jails of this size, housing units are typically more in the 60 to 72 bed range, not 20 to 48. What does that mean to the county? If we look at your current general population capacity, that excludes mental health, medical, females, folks who are in smaller housing units by their nature, we have about 1,344 beds in 36 housing units. Now, in order to staff a housing unit, it takes 5 staff minimum, 24/7 to do that. 3 shifts a day, 7 days a week with relief, comes to about a factor of 1.7 for every 24-hour position, about 5 people. That means that today, just to staff housing, it's 180 correctional officers that the sheriff has to assign just to housing. That doesn't include staff for movement to everything else. So it has a huge impact on operations. And then when there is people sick or people don't come in, housing gets staffed first. So all the programs, mental health, access to the public defender, moving people to see attorneys, gets cut. If we looked at using 48-bed units, housing would require 140 staff. If we looked at 64-bed units, housing would require 105 staff. If we looked at 72-bed units, housing would require about 195 staff, or a savings of about 75 to 85 positions. Now, that doesn't mean it's a direct dollar savings, because there's other things that aren't being covered. But on top of this, we've now cut down movement, which improves safety and security. We've improved access to programs. We've done things that go on both sides in terms of efficiency of operations and effectiveness of what we're doing in the jail. The other thing we really spent a lot of time on is intake, transfer, and release, because this is probably, while the housing represents the biggest area of the jail, intake, transfer, and release probably represents the busiest area of the jail. You know, we have 2,000 people in beds. We're probably moving 30,000 people a year through intake. You know, people that are coming in and going out. And this was a very broad-based discussion. We talked about it being flow-driven, and this is where, as we develop the architectural program, the steering committee is going to have to deal with a lot of issues about what's the operational impact and the benefit. For example, do we consider going to central booking so that everybody goes to one place to be processed? It was looked at before, Mr. O'Malley, about 10 years ago? Looked at as a good idea. It was difficult to implement. It's a challenge, but it's important.
You're on our way there, just got sidetracked.
Oh, maybe we can get back on the right track, or a track. Pre-trial screening. The city's had huge success with pre-trial screening in terms of when the city came in, they were 240, and now they're at about half of that through pre-trial screening and release programs. What if that was expanded countywide? Prosecuting attorney charging review. This actually came out in a courts meeting from Mr. O'Malley about the prosecuting attorney would like to review charges earlier. Why do we do that? If somebody's brought in as a felony, they may be there for 3 to 5 days before they even get to arraignment. If that felony is actually a misdemeanor, they may be eligible for release. So this is an issue where we will be dealing with some issues with the committee and the county about funding other kinds of things that will have a huge impact on the jail population. And more importantly, it will have a huge impact on human capital.
One comment to make at this point. These initiatives, while all of them are critical for our long-range planning, all of them in some way, shape, or form can be implemented now in short-range planning. So there's a transition. So, there are process issues, and then obviously there's infrastructure issues, but all of these can be implemented in some way, shape, or form, but we have to plan how they're done now for how they would transition in the future. So it's not a just then issue, it's a now and then issue.
And not to steal Karen's thunder from later, but if we start to think about these things now, we can test them out to actually prove how many beds we need to build and have an impact right away. These things don't require a building to make a change. Curtis, you had a question?
Yeah, well, no, the next slide is the Harris County.
Let me...
Okay, let me finish, okay.
Yeah, some other things that can happen here that we've seen which were issues, and I know in our first couple meetings we got some feedback that we talked a lot about what the court was doing versus what was happening in the jail. Yeah, we missed the opportunity for specialty court assignments. By having pretrial or court services in intake, a determination can be made. This person's a veteran, he's eligible for Veterans Court, let's move him there now. A decision can be made that with the prosecutor and the public defender, hey, this case looks like something that could go in expedited calendar. There's a lot of things that can happen through how we set this process up. Good.
Yeah, so one of the examples we're showing, this is a facility we stated earlier, we do want to do site visits. This is one we think would be beneficial, both for this project and the diversion project, because Harris County, that's Houston, Texas. This is a true central intake assessment center. All the things Andy just talked about are visible and in operation today. This is a new facility opened up earlier this year. One of the primary missions, it did two things. One, it consolidated, it is true central intake. This serves the entire county of Harris. Houston obviously is the biggest city within that county, but there are 45 towns and cities within Harris County, very similar to Cuyahoga County. Everybody's brought down to the central location for booking. One of the incentives that happened here was designed so that the law enforcement agencies that are coming in here can be in and out within 15 minutes. One of the other critical concepts of this facility was diversion. It is all about diversion. When you come in the front door of this facility, you begin to talk to the diversion desk. If you haven't been diverted in the community, which is the first place when you get arrested, which is a very big part of what they do in Houston particularly, when you do wind up in the jail, you start with diversion. If you cannot make it through diversion, then you go through the booking and intake process. You talk to pretrial services. On the upper left-hand corner or bottom corner, there is a defendant talking to pretrial services. On the upper left-hand corner, that actually is the waiting area. The booking area does not look like your typical jail booking area. There's natural light, soft materials. The offenders sit, or the people who are the detainees, are not offenders at this point, sit in comfortable chairs waiting to be processed through the facility. Again, the focus on pretrial services, the focus that the courts are located, and there are 3 courtrooms located in this facility. This is a big facility. This is 178,000 square feet are dedicated just to processing. Yes, they are processing 3 times as many people as you are here, which is about 35,000 a year presently. But it is designed to be efficient. It's designed for diversion. It's designed to justice is sped up. Yes, Mr. Stanton.
Yes, please, but, and this is marvelous about Harris County. They have a marvelous facility. Let's not forget that Harris County had an injunction filed against them because they were holding defendants in that facility on money bail considerations, which were a violation of the Equal Protection Clause, which was upheld by the 5th Circuit down in Texas. So let's at least put it in perspective. You can build a marvelous facility, but if you're not going to have bail reform, you're still going to have too many people in the jail.
I think everybody would agree with you, Mr. Stanton, 100%.
Thank you very much. Because none of this means anything if you're not going to amend it at the front. You can talk about diversion all you want, okay? But if you don't amend it at the front and have an epiphany in this county or any county across the country about not holding people in jails when they shouldn't be in there because they're there because of money considerations, I don't want to see photos. I don't want to see beautiful facilities. I don't want to see about cost cutting. Because if those people are still sitting there, you're not going to save money, okay? Thank you very much, and I won't say anything more the rest of the day.
But this facility.
No, please do.
Point of order, he didn't end with a question.
Because my questions are never answered.
So, by the way, I will say there's nobody on this panel that disagrees with you. We're going to let the epiphany part is for Karen.
Right.
And I want you to speak again because you have to underline what Karen has to say. Everyone understands that and we've been trying to emphasize from day one, the facility goes along with the process. If you abuse the process, the facility isn't going to matter. However, if you have a good process, it's not going to work well without the facility. They go together.
And to answer Mr. Stanton, you're correct. But just so you know, in the planning of this facility, bail reform was anticipated before it became the common buzzword it is to now, how important it is to our justice communities. Bail reform, this was designed to facilitate the ability for bail reform to happen expeditiously so people could come in and out very quickly. That was part of the planning process, just so you are aware.
Thank you very much.
And in fact, Mr. Stanton, if I may, one of the things we always talk about when we do a project like this to all of our clients, you have a choice. You can build a monument to the past and keep doing what you're doing. Or you can think about how to make the future different. And even though we're architects and planners, we're kind of talking about the underlying issues here that will make a difference. A difference for the county in terms of efficiency and effectiveness, and more importantly, a difference for the citizens that run afoul, perhaps, of the criminal justice system. You think about that person that comes in that Mr. Stanton just talked about, that ends up being held for 3 days, doesn't show up for his job. Guess what? Now he doesn't have a job. That's really where the rubber meets the road in terms of how we talk about what the future can be. And yes, we're talking about facilities, but the importance of continuing to bring these issues up is we are hoping to program for a future. And I would hate to have us develop a facility like that and have every one of those pretrial windows empty because there's nobody sitting there to do it. That is a critical issue that the steering committee and eventually the county, because that's where the budget sits, will have to be part of in terms of determining what the future can be. So with that, we'll take a look at some more pictures. I'm sorry.
Highly persuasive.
Working in our working group, we showed 3 or 4 different ideas about what modern booking could be. This is a modern booking area. It sets around what's basically an airport waiting room. And you'll see a video in a moment that talks about males and females sitting in the same waiting area because it's managed. We can do things differently. We can treat people like people. People sit here maybe 15 to 20 hours to get out. If you notice, there's so many phones in there. They don't want people to have 1 call. Make 20 calls if that'll get you out of here. So what we're going to do is and one of the things we also try to do is, as I said, we're architects and engineers. We think sometimes it's better to hear from people that actually run places like this.
The old intake facility had a sally port which was public facing. And so public that either resides across the street from the facility or that were traveling down Silver Lake Road or were in our parking lot could actually see the activities that were going on in the secure fenced sally port. That created a security issue in that as the gate would open and close for patrol vehicles to enter, it was also possible for someone else to enter as well. It also created a situation where we didn't present the best public-facing side of the facility, if you will, to the public. And so we were able to relocate that so that it's now accessed from the rear of the facility, or at least behind a screen, a wall, so that the public no longer has a view of those activities. Additionally, we were able to separate that sally port into 2 sections so that the prisoner transport vans could load prisoners to be transported to and from court without interfering with the accessibility of the sally port to officers who need to book inmates.
When one gets booked into the Pima County Jail, one comes into an outer booking area, and there are concrete benches out there, but again, it's clean and light, and they very quickly go through the booking process. Officers go through even more quickly. They start their person off, and we take it from there, and the officer goes back out onto the street. Once the person has gone through the initial booking, they go into our main intake area with the lower level. The first thing that happens in there is that they're dressed out, and any searching that is necessary is done, and there's a private place to do that. And the next event is to see the nurse for a more extensive interview, and they go back into their seating area after that. And then they're called up for the identification process for photographs and fingerprints, back into the seating area, and then called up, many of them by pretrial services, to talk about conditions of release. And we now have a public defender that sits in that area as well and does some interviews of people arrested for felonies. They go back into the seating area, and the next event is the initial appearance. And there's actually a courtroom right there, and we have a video link to where the judge is, and then the judge actually comes over for some cases in certain circumstances. One of the advantages of this process is that we don't have to dress people out and find housing for them as we once did. Their property is put in little drawers, readily available for the majority of people who actually get released after court on either on their own recognizance or on various conditions and bonds. And then we can return the property to those people, and they go on around the room and out the outdoor, and not to be seen again till court.
One of the things we're also cognizant of when we do projects like this is we're talking about major change. And whenever Curtis and Judy and Cheryl did a workshop, it was, we're going to have that many people in an open area? How safe is that?
When we opened, our SWAT team came over for a tour of the new facility. And they predicted that they would be back within a week for a riot. And we have not seen them since. And it's been over 2 years now that we've had intake open.
So it does prove it does work. And I think the other thing that's important that
when we opened,
that we try to bring to projects is, what is the impact of what we do from an environmental design perspective on people?
We had a regular visitor to our jail that was arrested on a regular basis that fought us every time he came in. And the first week we opened the new ID unit, this fellow was arrested and brought in, and when the officer brought him from booking into the ID unit, he looked around and said, "Is this where I'm going to be?" And they said, "Yes." And he said, "Well, I won't fight you anymore. I just used to fight you because you were going to put me in those small cells with 11 other people." And so the benefit right there was our incidences of assaults on officers went down, and our industrial injuries went down drastically. So in the long run, we're saving money for the county taxpayer.
So that's what we're trying to do in terms of our new facility. We also talked about special housing and what we might do for mental health. Judy, you want to chat about that for a moment?
Sure. One of the things that is very clear, I think, from all the things in the newspaper and things that you've been hearing about the jail, is that there are many, many people with serious mental illness sitting in the jail. In fact, in this country, 8 times more people are sitting in jail and prison with serious mental illness than have access or are in hospital beds. So it is a reality of something that we need to deal with. For mental health, we want to get as many of those people diverted out as we can. But the reality is that some of these people are charged with very serious crimes. And so they are not going to be safe to the community and they're not going to be released. So we need to think about how to house them and treat them within the jail. We're going to have smaller housing units. That may mean that we have a 24 or 48 bed jail housing unit that has subunits within it. And a major difference is we don't have double layers. What's it called? No, I wasn't talking about stacked beds. The mezzanine, that was the word that was escaping me. We're not going to have stacked bunk beds. We're not going to have mezzanine levels because that's unsafe. People with mental illness will find ways to get through that, go over the bars, hang themselves, etc. It's also important that we have integrated treatment teams. What that means is that the officer who's doing that management of the unit is part of the treatment team along with the mental health professionals who are also based in those units. They're not somewhere else sitting down in a clinic, but in fact they live in the housing units along with the patients, and they are patients for the mental health staff and for the inmates or detainees for the officers. We want a normative environment, we want access to out of doors, and we also want to remember that the staff are incarcerated as well. And being incarcerated and working with special needs patients all the time is very, very draining. So we need to provide an environment for them to also get away, recharge, and come back in and realize that they are a treatment member as well as a security member.
Interestingly enough, yesterday in our workshop, your medical provider talked about the fact as they dug into the records, probably 900 of the people in the jail today would qualify under SMI in terms of their psychosis. The part of this is the acute care unit. The other part is having mental health treatment rooms at every housing unit, because a lot of these folks will still be in the general population. Today, we've got to move them somewhere in order to get treatment. Now we can have the mental health clinician come to the housing unit, use the same officer for supervision, for safety, and do the kind of treatment we need to do. Just a couple other things we touch on.
By the way, we're going to have a break in 5 minutes.
Yeah.
So hang out 5 minutes and we'll be done. We'll have a break.
This is probably one of the most important things that the steering committee and the county is going to have to deal with, which is creating a robust jail management information system. I know that the sheriff and Rhonda have been working with internal jail bonding profile, but this needs to go beyond this. They needs to be able to pull in court data, some of the great work the prosecutor's done, some of our best information we got from the prosecutor's independent database. You want to know, for example, how many people this week are in jail that have a $3,000 bond and no other holds? That's a group to target. You need that kind of information to manage the population. Karen and I have done 2 major studies, which both resulted in new jails and new courthouses. Maricopa County, which Ken worked on with me. Where's Ken? We did the jail and the courthouse. Philadelphia, new jail and new courthouse. But their ultimate plan, which this steering committee may need to consider, was 3-pronged. Courts, jail, information system. And quite frankly, those information systems were $20 to $25 million. They were major events because you need to figure out how to talk to the court system and pull data in so that you can get a court list and know who you're moving. You need how to get information from the prosecutor, get information to the public defender, but yet have firewalls and things that people can't see. It is a major effort, but it's probably the third leg of this stool eventually that will allow us to right-size the jail and to use it properly. And I think that may be the last one, Jeff? Yeah. Yep, that's kind of the summary. And we'll be continuing this. And today, yesterday, these couple workshops that Dan and I did are really just, and Curtis and Judy are just about to start to think about what we can do. Eventually, all of this will come back to the steering committee to say, we agree, and more importantly, we also agree we need to fund these kinds of things to make it happen, because it's not all about the building. Jeff?
So on other projects, I'm supposed to be the on-time, on-budget guy, and I can tell you right now, we are not on time in this meeting. We spent a little more time on the first topic. So let's take a 10-minute break, but please, please, please come back within 10 minutes, because we really are going to move through the rest of this and get to these determinations. There's a lot more information to impart. So it is 10:40. We'll start up at 10:50. Thank you.
little bit more than. And they just. Especially courts here sometimes, but they don't mess around there.
Hey, how are you, Barbara? Good. Everything's good. Yeah. I do. Every day. I love it. Yeah. You know, we are the medical care providers.
Oh, okay.
So they talk about us, hi, hey, cute hair. I thought maybe it would be good to be in the room and talked about the ones. And sometimes we come up, yeah. And they're asking us for information and data constantly on the mentally ill and maids. Yeah. Yep. You got a lot going on these days. Every day. Does it ever stop? No. I bet.
I've got, you've left like
Oh, right.
3 years too.
Good. Good. I'm sure you're looking forward to that.
You know, everyone says,
No, I'm at 29, and I need 2 more because I was in that grandfather. So when they made that 25 years and up, I was at 24 years.
oh, okay, because I hit a nice
chocolate covered digest.
Okay.
25 and 50. So I'm doing the pitch box.
If there's anybody else that has public comment on issues 3, 4, and 5, any other public comment? We got to sign in for public comment. But I figured at that point in time that was the last.
Okay. No, it's a different one. Oh, that's right. Okay. So we're working on so you said you use that. So we're using that. Okay. And then the other one is, but it's under current affairs right now. Yeah, but they've got one principal. So do you know if there's any asbestos in there? No. How would I know about it? Yeah. I would have to T-bar hours. Yeah, because once I... Let me just everything. Thank you. Yeah, yeah. This is where the best of it. Well, yeah, but then the concerns, it's like, you know. In our basement? No, there's not there. Yeah, but that might become.
can get to our seats. We're going to cut out. I'm going to tell you what we're going to do now. Do we have our... See if we can get our folks back here on the... Let's see if we can get our... We have 3 people missing from the... Okay. What we're going to do, I'm going to save some time. We had a little bit more in the way of presentation, particularly on determination number 5, but we think that we have really, we spent a lot of time talking about the need for all of these procedures that have to be put in place. So we're gonna have a little bit less of the presentation. It's a lot of what Karen did actually at the last meeting with some additional information. So right now what we're going to do is we are going to take the 3, 4, and 5, although we may vote on them in a different order. We may vote on them in the order of 3, 5, and 4, only because the point is made that the justification for the number that we have on the jail population is dependent on having a process to make sure we do some of the things we say we're going to do. But what we're going to do now is ask our presenters very quickly to just go through what the determination is that we are proposing. We're going to put that up on the board to explain quickly the basis for the determination and to get questions from the steering committee. And this will be the steering committee dialogue first. After we get done doing that with these, then we'll take our public comment and then we'll vote. So that's the process.
Ladies and gentlemen, the first determination to be made has to do with our recommendation here on the number of judicial officers and as a basis for planning subsequent litigation spaces and indeed the rest of the program. The number of 94, you'll remember, arose out of a series of projections we did that looked at population, caseload, and then arrived at a judicial officer number. There's some inherent, I'm going to call them concerns about whether or not the caseload actually declines that far or whether it might decline further. And as a consequence of that and the possibility that there may be other factors that impact judicial numbers, we set up a range here of 90 to 94 as the basis for planning. This is not a determination of how many courts and how many judges the system should have. It's a determination of how many you can reasonably expect based on the historical trends. That being the case, we are looking subsequently then for that determination to take us forward into programming and allow us to deal with the whole issues of litigation spaces, both in terms of number, size, and relationship to judicial officers. I would simply point out that this determination of the range between 90 and 94, we would be, if factual basis is presented for some other number, meaning that there, for example, that there was legislative action changing the number of approved judges in Cuyahoga County, then we will change the program accordingly. If that changes, we will change, is basically the message we want to present to you. So that is our determination, and we hope that you will approve it and look forward to answering any questions you may have about it. Yes, ma'am.
In the materials that you delivered last time. Yeah. I did, it's on. On the core projections thing, it says that judicial officer projections reflect a reduction of 5 full-time employees, which corresponded to a reduction in 50,000 square feet and $43.8 million in project costs. Could you explain that a little more? I don't quite understand the $10,000 per 10,000 square feet per FTE.
You want to answer or you want me to? Okay. What we've found as we go across the country is that judicial officers translate generally into a certain amount of space in the system. It's not just that each judge gets 10,000 square feet. Please understand that that's not what we're saying. What we're saying is that the combination of litigation spaces, support spaces, judicial offices, and the ripple impact of that in the system can be 10,000 square feet. And so every judicial officer saved represents a potential lower number of about 10,000 square feet. Now, I just want to make this really clear, that courthouses are different place to place. So a very, very tight courthouse that only included, for example, the clerk and the court would be one number. When we expand it to include the range of services that are here, including the prosecutor, the public defender, all of the programs associated with the other courts, that number per judicial officer may well be higher. But in any case, we just take that broad number, apply a square foot cost to it, and that's how the number was arrived at.
Kind of piggybacking on that, with a discussion of some reforms and how things are carried out to reduce jail spaces, did you factor in whether there would need to be additional judicial staff because of any of the programs that may come to be?
We are working on that at this moment. I will tell you from the interviews we've had in this last week that we've encountered both lower staff in some respects and higher staff in other respects. So I don't have a sense yet of how this relates overall, but what we're trying to do is look at the emerging programs and say, here are some that are fading out. We don't need these anymore, or we certainly won't need them in the future. And then those that are really taking on more life and will be larger. What the total numbers are on staff, we don't know yet. We're still working on it.
I need to make something very clear here. What we are talking about right now is a determination at a point in time for the purpose of creating a baseline for the planning process. We will come back to you because we're continuing to evaluate, look at information, have meetings. The number could change. But we have to have a baseline to move the planning process forward. And you have to understand if it changed, why did it change, and it changed from what? You have to start with a baseline to keep your planning process going. So these are about baselines. These numbers could change based on new information as we go forward. So I don't want anyone to believe right now that because I voted on this, it's a mistake or it's a problem. Because there's really no completely wrong or right answer. It is the best determination based on the information we have right now to make a determination to move forward. Now, if we adjust it, it requires another determination. However, the idea here is to create a consensus baseline that we can move forward on. And I want that to be made clear.
Yes, ma'am.
The trend in terms of some of the judicial planning that's going on is to have specialized dockets and treatment courts. I know on the initial slide when we were talking about population and case number, you know, Cleveland has been the leaders in terms of the specialized dockets. We've got a number of specialized dockets. We've allowed the suburban courts, we've partnered with the suburban courts to service them as well. And I don't think that that number was, or that information was taken into account when we're looking at some of these trends, and I want that to be noted. And in addition to we have 4 dockets that are certified by the Ohio Supreme Court, in addition to a number of other specialized courts, and, you know, I think Cleveland's one of the leaders in doing that.
Judge, I'll just reflect on that in this way, to say that there is a difference, and I think we've discussed this before, between caseload, filing load, and workload. And we certainly recognize the potential additional workload that is associated with specialty courts. I think that in our filing projections, we actually projected at least a short-term increase in municipal court filings, and expected that when we do the space planning, we will focus not only on that basic fact, but on the impact it has on your specialty courts as well. So just to say that workload we know is different than caseload. We know that your workload is expanded in some respects. We also know that there is this long-term trend or inertia of decline, and we've tried to moderate that over the time because, one, we expect population to stabilize, and we also expect that the caseloads will stabilize to just slightly decline as we go forward.
Other questions?
Thank you very much.
Okay, thank you. Then we're going to move on to, for discussion, for presentation to 4 and 5. Karen? Put the determinations up to explain the determinations. Then Karen, you'll have to decide what slides you want to use. Use your lavalier.
Everybody hear me?
Can hear that.
Yeah, can you hear? Okay.
Yeah, okay.
Good morning, everyone. I had a longer presentation. I wanted to summarize what we saw last time to talk about trends in the jail, the profile in the jail, and then ultimately the forecast, because it is such a huge monumental decision about the size of the jail. And so to summarize, I used historic data to develop projections. There was a high, medium, and low growth scenario on the projections, looking at how you've grown over time. And of course, in developing projections, I had to use average daily population in the jail because that was the database to develop projections. But that would then presuppose that everybody in all those years and all those months of jail data I was looking at would have been there or should have been there if in the absence of any kind of alternative in the reforms that we've talked about, which we don't need to summarize again, but certainly looking at bail reform, pretrial services, central booking, all those kind of things that can really have an impact on the jail. So the determination number 4, I'm suggesting and recommending that based on the assessment of the system, the profile of who's in jail, and various patterns of growth over time in the jail, that initial planning for the jail capacity would be 1,600 beds with a support core of 2,400 beds. Because it will take at least 3 to 5 years, or I'll look to this team longer, before a jail would be opened. Actually, that's a fast track schedule. So there will be time to see if the kind of key reduction strategies that have been recommended that I've have in the report summary today, and you've got before you can read through that, and many of which you've all been part of committees to look at over the last 3 to 5 years, such as bail reform and pretrial service and central booking. You've looked at that before. If those were to be implemented, and you can monitor over time with good database and information management, before a new jail would ever open or a renovated jail would be renovated, you would be able to see the success of how those initiatives could bring the population down. So the initial capacity would be 1,600 beds with a support core for 2,400 beds. And as Andy had said in his presentation, as you saw, it's not going to be a lot of additional square footage to say if you do a support core for 2,400, because many of the services, if you do have to add additional jail beds, if you've got to take the population up to 400, and certainly any renovation or expansion or new facility would be master planned for that possible expansion, most of the services and most of the square footage is going to be in additional beds and additional housing. You're not going to have that much additional square footage in a laundry facility or even a kitchen when you go from 1,600 beds to 2,400 beds. So what I'm recommending is the 24 for the core, that we could begin, Curtis and his team could begin programming for the jail, but initial occupancy would be 1,600.
Just to be clear, when you plan this facility, they're going to be core services no matter whether you have 1,600, 1,800, 2,000. And these core services, whether you're talking about your intake system that we talked about, whether you talk about food service, whether you talk about your medical facilities, the incremental difference in cost in the core, whether it's 1,600, 1,700, 1,800, up to 2,400, there's some incremental cost to make it slightly larger, but that is not your big cost concern here. The cost concern are the jail blocks. And we talked about jail blocks as, modular 64 unit type modules. They can be adjusted. The proposal here is to have the core services big enough or robust enough so it can be 1,600 to 24, because that's not that big a difference. But then to plan the jail blocks at 1,600, which is a big difference. And just to give you an idea of what we're talking about here, I believe on Friday there were 2,200 people in the jail on Friday. We do get a count now, I think it's through the prosecutor's office actually, that we get a count 2,200 people in the jail on Friday. So even though we've talked about this reduction for months, we're still at 2,200. This would be a reduction of 600 individuals, in that jail. The cost of that, just that cost alone, to go from, and by the way, it's not that we actually have a jail that can actually support 2,200, but if we were planning for 2,200, you'd have to plan it to support that. That cost alone for those 600 is going to be somewhere north of, that difference alone will be somewhere north of $100 million in construction cost, and it'll be somewhere north of, and we could do it quickly, $25, $26 million a year, something like that, in operation cost. So over 10 years, just the difference between 2,200 and 1,600 is hundreds of millions of dollars. Yes, Harmon?
I just want to, because this is on the record, I want to say that, first of all, thanks to the courts who have been very helpful, and especially the prosecutors who have been super helpful. Today, I think our number in the main jail is down to 1,905, the sheriff just informed me, and total
Okay,
in
all right.
the jails is 1,985.
Okay, this was, what was the data?
As of yesterday, I pulled the jail dashboard, it was 2,078, so, yeah.
Okay, so okay.
Yeah.
Right,
It's in
but
the
the point,
2,000 to 2,200, yeah.
yeah, the point is whether the number is 2,000, 21, 22, or grows to 26, you pick your number. We all understand the benefit of getting it down to 1,600, and I think there's a common mission to figure out how to do that. But the point for us to make here, though, is for planning purposes, we have to plan. We have to have a target, and that's critical, and we have to commit to it. But in order to commit to that target, all these other initiatives we've talked about have to occur. So go on with the second part.
Okay, well, just a very quick summary. The profile assessment shows, as we see across the country, there are socioeconomic factors that really contribute to the jail population. There's many very successful strategies. Not only do you be saving capital costs and operational dollars, but in terms of your community and the human collateral damage that happens if you over-incarcerate people. And I developed this slide because I've been in this business for 35 years, and then 35 years ago, even 20 years ago, it was build and fill. You couldn't build it fast enough, and particularly in the state of Texas where, and I do want to point this out to Mr. Stanton, that the Harris County facility, I'm circling here on current vacant capacity, and every single day, average daily population, any jurisdiction changes. But a lot of the work that I'm doing now, and I brought up Mecklenburg, but other jurisdictions, I'm planning for what do we do with all these empty jail beds that we have, because we have turned the corner in our society about incarceration being the answer for everything. So all the kinds of things you're looking at here about diversion, bail reform. When this has been done, and you've got good examples, and it's tremendous amount of work that will take place in a concerted effort and coordination over a number of years. But where it has been done, there has been no negligible effect or any negative impact on public safety and no increase in criminal activity. So the outcomes of other strategies are much more long-term successful than just 20 or 30 days of incarceration or longer. And I just wanted to point that out because now as you are looking at either renovation or new construction and a huge monumental decision, what I'm seeing now is the backside of what we did for 30 or 40 years, and just as a cautionary tale before constructing a lot of beds. The next determination, is that what we're doing now? We have to go to the next determination. Apologize, our presentation has been changed around a little bit.
Go back to determination number 5.
Oh, okay. Determination 5. Well, this has to do with the fact that in support of population reduction strategies, and what I just mentioned is that there is significant evidence. We see it in the paper every day. I've tried to put as much as I can in those presentation materials from last time and this time, that there are reform initiatives can have a tremendous impact on the jail population, and that implementing these does not come without a cost, because of many, and there's some examples in that today's handout. It doesn't mean don't build the jail bed, there's no cost. There will be issues in terms of there will be cost to pretrial services, there will be cost to develop bail reform, there'll be cost to develop a central booking operation, and diversion programs and mental health diversion. All those things cost, but at much less cost and longer term impact, positive impact. So the determination is that there would be funding for a jail population management committee and initiatives, because it's not going to happen on its own. There's going to have to be a committee overseeing for leadership. There's going to have to be staff assigned to be looking at the jail population and developing an integrated database. And there's going to have to be ongoing monitoring about how these initiatives have impact on the jail population before you ever get to a new or renovated jail. Oh. And in more detail in the handout that you have today that I was going to present, but what are these key strategies? There's many things that can and should be done to reduce the population. The first one, again, is information management and an integrated justice system information, so that you can be monitoring any initiatives that are implemented, and that again will take a tremendous amount of leadership and development of an integrated database. The next one was diversion at all points of the criminal justice system, and there's a few graphs in there that it's not just waiting for the front door of the jail to do diversion, although that's the most critical area to look at and make a diversion, but from the point of law enforcement to prosecution, anywhere that you have in the community before you get to the front door of the jail, any of those kind of diversionary programs that will impact on many of the socioeconomic factors that bring people to the justice system is going to have an impact on the jail. Development of mental health diversion capacity, whether it's facilities or other programs or retooling the programs you currently have in the community. We know, and again, Andy mentioned it yesterday, at least 41% of the population as of yesterday in your jail has a serious mental illness. And Judy mentioned some of the issues about how behavioral health facilities now, their main ones are in our jails in America, and that can be changed and would certainly reduce the population in jail. Central booking, we've talked about that, but having a uniform bond schedule and having complete equal treatment of all people that are coming into the justice system is going to be critically important. Pretrial screening and services for all the courts. You have an example right here in your Cleveland Municipal Court of the impact that that's had, and of monitoring people to ensure their appearance of court, and you've had greatly reduced failure to appear rate as a result of that. Also, comprehensive bail reform. The Ohio Supreme Court put out recently recommendations on bail reform, but the work that was done here in Cuyahoga County, I think, was even more extensive. And anywhere where, again, bail reform or elimination of cash bail has happened in our country, no increase in crime, and in fact, no negative impact to public safety. So we've got a lot of evidence of that. And then certainly enhanced operations and space allocation at the jail. Because obviously the jail, in terms of delivering inmates to court on time, releasing on bond when it's been posted, all those kinds of things holistically can have an impact on reducing jail population.
And this is a county-wide initiative, and the framework does exist to make it happen.
To begin the process, right, to take on the responsibility of us. It will be a long period of time, and again, coordinated cooperation from everybody in the justice system with leadership to say, this is the path we're going on in the absence of building 3,500 or 5,000 jail beds in our community. But it's not going to happen overnight, and it's not going to happen with a great deal of work in this community.
Let's go back to the full determination, and I want to talk a minute after you go through it, because there's actually, I think, 2 slides. So Karen, I mean, you've already been through the first 2. This is simply the sort of the finding. And the point here, well, go back. The point here is that when it says determine that funding for jail population management initiatives should be given equal weight, that doesn't mean that $1 is $1. It means that on a scorecard, if there is something that demonstrates that if we do X and it costs $1 million, but it saves $5 million in capital cost or some other cost, such as information management, that should be weighed. And we should talk about absorbing that cost in some process to avoid the larger capital cost. So that's what that means. Then go to the second page.
If I may,
go ahead.
Just to add something to what you said earlier, the general formula is that in 30 years, 10% of what you spent is spent on capital. So if we use Jeff's example of $100 million, you take that times 30 over 30 years in terms of operational dollars.
That's right. So we have to talk about those. We have to talk about this holistically, is what I'm trying to say. It doesn't do you any good to save a few dollars in one category if it means you're going to spend 10 times that much in another category. That's the only thing we're trying to say with that.
Jeff, one question.
Yes.
Would you advise us? I mean, some of these things we should be in something regard to neighborhoods and convergence. Would you suggest that we really go full bore now into those issues so that we see a stabilization of what the jail population is before we start saying this is our number? So we saying independently, all these things should be done right.
And I will just tell you, I mean, and I want to be a little cautious about this. It's a who's responsible. We're going to get into that, but here's the whole point: diversion. And we've already started the diversion meetings. We know that there's no reason not to begin that implementation. Now, there can be temporary diversion and then the final facilities later. Information management. I mean, if we could have had this meeting 10 years ago, I would have said, do it 10 years ago, but we have to do that now. And I will have to tell you, what's even currently being done is not necessarily what really needs to be done. That has to be evaluated now, no reason to wait. I know Mr. Stanton would like to wait on bail reform, but I suppose we could get into that now. I mean, all these issues are now issues. Every one of them. I was trying to be facetious. Don't get angry. All right. Very good. But almost every one of these things, and whether you want to talk about central booking, central intake, all those things could be done in some version now. They evolve later. But what I want to talk about here, and we've said, for lack of anything else, setting up a jail population management committee. Here's the problem, or here's the issue. Unless this is done in an integrated way, it's impossible to do. And I'll tell you something else. From our perspective, as we continue on the programming, it's not just programming right now. It's going to be programming, until whenever, April, but then it gets right into planning. And there'll be more time for planning. As these numbers change, there has to be information flowing back to programming and planning in an integrated way. Okay, this has been successful. We can cut this down by 50, put this up by 100. There's got to be an integrated way for a committee with someone taking charge of that to say, okay, here's where we're at on each one of these initiatives. This is what it means in terms of facilities. This is what it means in terms of number, to report back to those people who are planning the facility in an integrated way so that we're not, or whoever it is, are not trying to talk to this person about how's this effort, what's going on over here. We have to have it in an integrated fashion so everybody knows the integrated plan and can report back on it. That's the concept. And at this point in time, we'd have to explore this a lot more, but the concept is a jail population management committee, and you can call it whatever you want, but that's the concept, representing all of the stakeholders, should be appointed to begin the process of developing a comprehensive and integrated approach to jail population management. There's something that I had actually prepared, and I'll send it to everybody, and it's a worksheet on this. It basically goes to all the stakeholders, and it says, okay, number one, from your perspective, who has to be in the room, not just by entity, but by individual to make this happen. Number two, for every single entity, what are the decisions that entity has to make? What are the actions that entity has to take? Are there legal actions or administrative actions or procedural actions? What is the overall menu to get these things done? You know, and then of course the question is, okay, once and even think of it in terms of a series of lock-the-door meetings where everybody who has a unique role in that gets in and you don't get out until you get to some of these decisions. I mean, it's that kind of idea. But right now it's just setting up the committee and commitment to do it. Keep in mind that this group said at the last meeting when I put the proposition, you all agreed these things have to be done, and then you all said, let's not leave or rely on others to do it. Let's take charge in some fashion. Well, this would be a method to start that process. So,
Mr. Stanton?
Yeah,
I'm
but
sorry,
my
Mark.
concern, and I'm a little thick-headed on this, but my concern is if we're not confining ourselves to those numbers. I understand it's just a baseline and a extrapolated high end, correct? Because
Oh, no, just the high end, going back, if we have continued history, you could be up to 4,800 inmates. So I just
Sure.
want to make, okay.
I understand that, but here.
Okay.
Just one minor example, all right? I had a clerk in our office go through the arraignments for the last month. The cases that were assigned to the public defender, we received 35% of the cases. I counted, and I've been doing this a few years, like since 1977.
Okay.
49 of the cases received personal bonds, as high as second-degree felonies, sex offenses, trafficking offenses, burglaries, that 3 months ago we never would have received personal bonds. How did that magically occur in the last 30 days? Because, again, we had an epiphany with all these judges that were in the arraignment room? Of course not. It's because 9 people died, okay? Because the day before the first person died, those same conditions existed in that jail. Dale Miller, who is the personification of a great public servant, and we're not friends, we've hardly ever spoken to one another. He wrote a powerful and certainly incisive letter about the capacity of the jail. And he said 1,550, and I said, I appreciate what you're saying. If we don't go down to 1,250, we're in trouble, okay? Because I'll tell you why. How can your county be reduced by population? Almost 500,000 since 1970.
Yep.
Or when that Justice Center was built, we had 956 beds built in the original jail. We had 325 homicides in 1980. I should know because I had 19 of them on my docket. Okay? We suddenly have less guns, or do we have more guns with less population in the city and the county? It's suddenly a more violent county? There's more drugs? I can remember the heroin epidemics of the 70s, the crack epidemics of the 80s. If you can reduce 150 people like that, okay, on offenses that would never have received a bond in previous months or previous years, you cannot have numbers like that, okay? You have specialized dockets where you don't have to have people on bond. So, okay, I'm gonna withdraw, okay? But let's not get caught up in numbers like this because I'll never concede that my research isn't correct. But you cannot dispute the size of this county, the size of the city, and the incremental loss of population and less violent crimes. It's pronounced we have less violent crimes. We have 30% less cases indicted than we did in the early 2000s. You know that, Mr. Mason, when you were the county prosecutor. 30% less, and yet we're bursting at the seams? They had no foresight in 1976 when they built a jail for 956. Keep building the jails a little bigger. People will find reasons to stick people in there. Thank you.
So,
My point is, I want to make sure that that's just a number we're talking about. And that we're working towards, hopefully, somebody is in concert with me here, that we're working towards lesser numbers on the low end and high end scale.
So I want to make 3 points on this. Point number one, it is a number at a point in time. We would be delighted to reduce that number, and which is why but we have to have input for that. We would be delighted to do that. Nothing would please this panel. I think you understand the passion of these programmers. They all agree. We still have to do it with some objective information. It can't be just the hope and the prayer we do it. So we're going to have the structure. We're going to have to start to see it, and then we reduce it. Now, I will also say this. You know, the way this process works, and just think about this if you want to, because the way this process works is we have the discussion, we have a motion. You know, you can propose an amendment to this. It could be voted on, because all I'm obligated to do is put the initial determination. Your committee can modify it, so you can think about that. But I will tell you, it's not static. But the point about 1,600 is we're not planning for 2,000. We're not planning for 18. We're planning for 16 with the core. Now, it does raise the issue of starting for a lower core. Excuse me?
It can go down also.
That's what I'm saying. It can go down. That's my whole point. It can go down. But the sooner we know and the sooner we see results, the more efficient the planning process is. Okay. Any other discussion on either 4 or 5, which is, 5 is, yes. I'm sorry, Judge Russo.
Just here on 5, we probably should define should be appointed, because that doesn't really say who's appointing, if you're appointing, if they're appointing, is this steering committee appointing, because that jail population management committee is important. We shouldn't forget about the CCDLA, who plays an important part, or the civil lawyers who play a part. So however who should be appointed to this management committee, I don't know how we determine that. Is that based on all of us here voting on who are those people? So I just wonder. Or are you going to appoint?
I'm not going to, I don't have that power or right.
Yeah, and I'm not trying to stifle, but we could say should be appointed, I don't know, at the discretion of all of us as the steering committee. I don't know, but it just leaves it out there and doesn't really say who should be appointed.
Well, I would suggest this. I would suggest that if this recommendation is voted on, what I would like to do is I would like to convene a meeting of steering committee members. I actually wanted to send out that information sheet, but then convene a meeting of the steering committee members to talk about, that committee. But
it could be to just add should be appointed by the recommendation of steering committee members, or
we'll do that. We'll do that. And we'll develop that process.
Open-ended, and then we start getting invitations from all groups saying we want to be part of it. I think there should be some.
You've had some history of this. I will put down. We will add to it. Should be appointed by representatives of by the steering committee members.
And I'm asking. I don't know any other discussion. I don't want to be the one to say it, but I just think it leaves it open-ended.
That would be. We'll make a motion on that. Let's make a motion. Let's get the discussion. That can be a motion. Hold that for a motion.
Okay,
as
sure.
one change.
Coupled with that, my question was, who are the stakeholders? It kind of feeds into that same discussion. That's all the stakeholders.
Well, here's what I would propose to do. I do want to send out this worksheet that I told you about. It will go to the steering committee members, get your thoughts as to, and then what I'll do is I'll get your thoughts as to who the stakeholders should be, et cetera. And then what I will do is I'll assemble that, send it back to the steering committee members. And what we could do is then have a further determination. I mean, frankly, we're going to have some time to get this done because we're going to be doing this simultaneously. So if we can do that, I'll gather the information, feed it back to you, and then we can get a little bit more substance on this as we move through.
They added some language there.
Yes.
They did. I don't know if that means.
Well, I think you have to vote on it, so we'll.
Yeah, I understand.
Yeah. Okay. Any other discussion right now on either of, or do you want to take them by the? Yes, Armin.
Just ask a question because I'm a little bit concerned, having been through the MOU process, that if we're somehow going to pick as a committee another committee, that could end up taking longer than building the building. So how about if we just made this steering committee the management committee?
We could make this steering committee the management committee, but then I'm going to tell you what we're going to do then. There will be a whole, and we're willing, by the way, I've polled my committee. We are willing to help facilitate that, but it would actually be this committee then having a series of meetings on all of these issues and deciding by this committee. We would be happy to do that, but I will tell you that's going to inject meetings of this entire group on these specific issues, which, and the question is whether you want to do it as a committee of the whole or do it as a subcommittee of the whole.
I have a feeling the subcommittee might not be smaller than the committee of the whole.
Well,
I don't know the answer, but now I'm looking at our two clerks. I mean, what do the clerks have to do with jail population? And not to say that they don't have input into it, because.
Bonds.
Okay.
Getting people out, moving people around, releasing people. I think we play a critical role, Judge.
Yeah, thank you. Sorry.
If I may add, Karen.
If I may add, and Karen, please comment, is that where these committees exist in other jurisdictions, they meet very frequently, almost weekly. So just keep that in mind about who actually would be the membership of this committee. Yes, Judge, you're right, those have to be most involved, but also this is a very active committee.
the other thing I would point out, it may be this committee, but you may determine to invite others. For example, some of these initiatives involve the municipalities, other municipalities, not here, other municipal courts. And for some of these initiatives, it would involve representation by the municipal courts. So, Mr. Budish, the problem is it may be the opposite. It may not be a smaller committee, it may be a larger committee. But the whole point is, everybody who has a stake has to be in the room, and we have to find a room with locks on the doors, and we have to get through this. We just have to. So what I would propose, once again, I would propose that it would be the initial committee would be appointed by representatives of the steering committee, but we take a larger view as to who that should be, and I would propose I will send around to everybody something to fill out to get your recommendations and thoughts about it. I'll assemble it and send it back to the committee, and then we can have a further conversation on who they are. We'll also start to prepare actually an agenda for those meetings, and actually how to go down these issues point by point. Because I actually think, what we've been saying from day one, it's part and parcel of what we're doing. You can't plan the facility without planning the system, and I think everyone's coming to that recognition. I'm sorry if your scope has been increased without fee, but that's just what happened. Okay. They're laughing. We're delighted to help with this. Okay, any other conversation or discussion on these determinations, understanding that on the numbers, it is a point in time subject to change. Okay, that's the one point I want to make. So with that in mind, let's start with let's actually go to number 5 first. Oh, I'm sorry. I almost how could I do that? All right. First of all, is there anybody else, Mr. Miller, if you could come forward, anybody else that wanted to sign up for public comment on this? Okay, Mr. Miller, who did send a letter, I think all the steering committee members received it, has a public comment.
Thank you very much. First of all, disclaimer, I'm speaking just on behalf of myself, not necessarily anybody else on the council. I call your attention again to the letter that I sent out recommending a target number of 1550. My goal is a jail system that is humane, equitable, and promotes public safety. I believe that our consultants were wise and right in saying that we should just not assume that current population trends are going to continue, but I felt that the numerical projections did not fully represent their basic premise. However, I'm more encouraged by determinations 4 and 5. Over the last 40 years, incarceration in the United States has quadrupled, and the reductions that we're talking about hopefully achieving would only represent a 30% retracement of that 40-year trend. So it's certainly something that is achievable, but I believe that to achieve it, we would need a higher level of cooperation, intentionality, and working together among all the stakeholders. And I saw a 2009 Cuyahoga County goal statement advocating bail reform, and we're still talking about bail reform. So what I'm recommending is that I strongly support determination number 5. We just have to work together and make that a priority. And I recommend that we adopt an even more aggressive target of 1250 to 1750 as the planning number. And with that, I thank you very much for your attention and consideration to my comments.
Thank you, Mr. Miller. Okay. With no other public comment, can we turn to determination number 5 first? Do you have the version where you put the red in? So we can, okay, so this is determination number 5, and the first.
Motion to move to add representatives of the steering committee.
Thank you. Motion seconded? Okay, let's vote on first of all, the motion to amend, then we'll vote on the entire statement with the amendment. So on the motion, and on the motion to amend, we'll just go around the room. Oh, I did say I'd start. See, you got a small one.
I agree.
Yes.
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 Yes. Yes.
Okay, we have a unanimous vote. And then let's vote on.
Now you started this side.
All right. Okay. I know. Now we need a motion for the restated. Judge Russo makes the motion. A second. It's seconded by Judge Celebrezzi. Any further conversation or discussion now that it's been amended? We're ready to vote. Okay, and we will now vote on this proposition with the understanding that we still have some work to do on creating the committee, and based on the information we'll send, and we'll come back to the committee on that.
Yes. Yes.
Yes.
Yes.
Yes. Yes.
Judge Hurley?
Yes.
Yes. Yes.
Okay, we have unanimous vote on determination number 5. Now let's go to determination number 4, because that's most related to what we just talked about. All right, this is the determination that, once again, for planning purposes only, at this stage, that we have a core that we will plan that can be from 1,600 or 2,400. The number will will be modified based on factual information, including input on these initiatives as we move through. And by the way, I want to make one more statement. You might want to ask, well, how and when can it be modified? Let me just take 1 second to talk about how this process works. Until this programming process is done, we will continue to tweak and modify. Right now, we will be very close to being done with that in the March, the big issues in the March timeframe, reporting out in April, and then concluding. Assuming we have a path forward, so modifications till then, even then, if we have a path forward, that's when we begin conceptual design with another RFQ, even during the early conceptual design phases, as we put pen to pencil, until we're done with conceptual design. Modifications and numbers still weigh in. So we need to set this up because we need to monitor this for at least a year, because we'll still be able to make modifications for at least a year based on good information. That's why getting data is important. Having this and having some history here is important. So we'll continue to make modifications during that entire process. With that in mind, is there any further questions or discussion before we vote on determination number 4? So Karen, my question is this more accurate based on what we said if it says of 1,600 beds?
Well, I think the point you made, Jeff, is that, again, it's going to be the next year, 2, 3, 5 years to monitor, because I agree with Mr. Stanton, it could go down from there. Again, the 1,600 number that I'm recommending is substantially less than if we were just going to use the numbers and repeat history.
I guess the point is, right now it's no less than. We have to have information, and then we'll reduce it when we have the information.
Right.
Yes?
You could adjust the determination to make it clear that it can also be reduced.
Where does it say that it can't?
We just change the word.
1,600 beds, four-core plan with no more than 2,400 beds, planned on a modular basis to allow the capacity to be adjusted upward or downward.
Type that in and see if we get approval on the changing it.
Type it in, let's look at that.
Yeah.
You have no standing to make a motion, sir. That's a good point.
Just a suggestion.
Would you make that red then? And you understand we talk about on the modular basis. The idea would be that all of the housing units are done in a modular component, whether it's, we hope it's not 24, whether it's 64. These units, you can add or subtract them as part of the process. Yeah, that's a term of art in the programming industry. We don't. You're right. Andy, put a W if you're going to do this on allow.
We could also strike this, just plan to allow upward or downward.
Yeah, I think that's better. Take out the on. And I do think that more accurately reflects the concern that we will come back to this number.
I'll just have another.
My discussion would be, why are we even putting numbers there? Why not just put to allow adjustment upward or downward? By putting numbers in there, you're voting on numbers that, while you're saying could be upward or downward, put a basis in there that we don't know the answer until your jail committee starts to look at it. I'm not even sure if this number includes what that hidden concern that we don't talk about but been brought out for the last 20 years is centralized booking. I mean, we don't have mayors from the muni courts. We don't have muni court judges that can make those determinations, council people from the muni court. So the numbers are very concerning to me as a judge on my bench and talking to my judges, because the numbers are put out there, and yeah, you're saying, yeah, they could be adjusted upward or downward, but why do we have any numbers at all other than the premise of we're going to make that determination.
I will give you an answer, then I'll let the programmers. We have to move our process forward. We have to create a baseline. We have to have a baseline so that everything we do is premised on the baseline, and then when the number changes, we can adjust everything else. If we don't have a baseline, it's almost impossible for us to move to the next step of programming. We can adjust it, but you got to start with a baseline. You got to know, because when we show you things then, and we tell you what we've shown you is based on this 1600 baseline. If it changes, this is what changes. But you have to see a baseline, or we can't effectively move forward. That's the technical answer,
Correct,
Judge.
Jeff. We need that, Judge, so we can do it. We're starting a programming effort already. It's driven by operations, but we have to start somewhere. So we have to have something to drive the square footage, which in turn drives concepts, which in turn drives cost, but it is adjustable.
And then when we show it to you, you see, if we showed you something, then when we show it to you, we can say this was based on 1600. If the number goes to 1500, here's what changes. If it goes to 1800, here's what changes. But we need to start with the baseline. It's kind of fundamental programming. When we did every project we do, anything from our hotel to our convention center to college buildings, we start with the baseline and then adjust it because everything is based on that and everything moves with the baseline.
Yeah, well, when we say programming, it's not treatment programs. It's the actual user requirements for the facility. So.
And just to say it again, for every individual, for every cell block, it implies what else happens. So that's the reason. Any other comments or discussion, Mr. Mason?
Yeah, I would say from the executive's point of view that we think we can meet that 1,600 number. Of course, we've got to have everybody's cooperation in the room, but we can get there.
Well, and when we see you pass this, we're all counting on it because we're going to design based on that. I mean, that's the key, subject to adjustment. Other comments? Other questions? Okay, so we'll do this again. We'll do this again. First of all, a motion to include language that says, to make it clear, plan to allow adjustment upward or downward, to make it clear that this is adjustable. Can we hear a motion to add that language? Mr. O'Malley made the motion. A second? Second. Various seconds. Mr. Budish, second. I think I'm going this way. Okay, so first of all, this is just in terms of the amended language. All in favor?
Yes.
Yes.
Okay, and we have that as a unanimous vote. And now, for planning purposes only, as we've said, we'll now vote on the determination to allow us to move forward. And we'll start with Mr. Stanton.
Yes. Yes.
No. And I'm going to ask the programmers, the reason it's no is as the administrative judge, I need the programmers to present their rationale to my judges on the assumption of the rated capacity, why and how you arrive at the baseline. Is centralized booking included in this? And I need that included in a discussion of my judges before I can vote.
And what I would say at this point, regardless of what the vote is, we will commit, won't we, to come to your judges and do that. And I will tell you, central booking is one of the assumptions. It is. I mean, because that's one of the ways you get down there.
I'm not saying it's not. I as the administrative
Yes.
judge, I need you to come and tell 33 others. I don't have the ability to make this determination on my own, so that's why I'm voting.
And the answer is regardless of the vote, we will do that.
Okay.
And we will make that commitment. Yes?
Yes.
Okay. So we are required to have a supermajority of 10 of 12 votes. We do have a supermajority. We also have a commitment, and I take it, Judge Celebrezzi, you'd like the same thing that Judge Russo is asking for. Could we ask, and by the way, there's no reason if we make the presentation you shouldn't attend, but could we ask that we set up maybe a joint presentation so we can do this in a unifying unit, or do you think they have to be separate? You tell me. Okay, Judge Russo, can we make these as a joint? And Judge Early will invite you to that presentation of the judges. Okay. So Give us 1 second. Now we go to determination number 3. Determination number 3, and you've heard the discussion about this one, and once again, it is based on a number of judicial positions. Right now, we are saying no less than 90, no more than 94, once again, subject to adjustment as we get more information. And it is a estimated ratio of litigation spaces that will be in the 75 to 85% range. And that is the statement of the determination. We also understand some of the basis for almost automatically adjusting it if the number of judges is adjusted by the state legislature. That would be, in essence, a one-for-one adjustment, up or down, in our view. So, in any event, is there a discussion on this determination? Is that discussion? Okay. Is there any discussion with words on this determination? Okay. Any proposed amendment to this determination? Okay. If that's the case, we will then vote on the determination, and I think we're starting over here.
Yes, motion.
Oh, thank you. Do we have a motion for this determination from the floor? Moved by Ms. Bates. Second? Second by Mr. Budish. Okay, now we'll vote.
Yes.
Yes?
Yes.
Yes? Yes? We have a no from Judge Early. No. A no from Judge Celebrezzi.
No.
A no from Judge Russo.
And my rationale will be that the baseline determination of the judge's position and the litigation space needs to be presented to judges in order to give the basis of your determination.
Okay, and let me.
As the administrative judge, I can't make that determination.
Okay, and I'm going to come back and see if that is if there are different bases, but let me just go on. Thank you.
Yes.
Yes.
Okay, so at this point in time, this determination does not pass. Let me go back for some discussion, and Judge Russo has stated what he needs, which is essentially the same as for the, you need your judges.
Rationale presented on baseline determination of the judge's positions and litigation space.
Okay. Is that?
Exactly what Judge Russo says. It is true. It has to be explained to my judges 75% to 85%.
Okay.
As the AJ, I have to have that explanation to them.
Okay.
And mine is similar, but I also have an issue with the not taking into consideration the specialized docket or the treatment courts, which was not done.
Okay. Did you have that? Okay. Give me 1 minute just to confer about an action plan, if you would. I think, first of all, this determination has not passed. There have been 3 no votes. We think the action plan is as follows. Our courts planning team will be back for 2 straight weeks starting September 30th. So what we will attempt to do in these meetings, so there's 2 meetings, are on the courts planning, and these do need to be separate meetings because each court is different. So we will reach out to you to schedule a time and place for those meetings with your individual courts. We'll go through both the numbers and also the litigation ratio with a lot more detail in historic data. And we'll schedule that hopefully sometime in that 2-week period. We can then, which by the way, we can afford to do in the sense that right now the jails are moving forward quickly. We would have a little time, we think, on the courts process. So this is not gonna, it's not gonna hurt our schedule at this point in time. So we can accommodate that. So that's what we will do, and we'll also plan the general meeting for all three on the other determination. That will be the plan of action going forward.
Thank you.
Okay.
Yeah. Is it appropriate to ask a question?
You just did, but you can ask another one.
I'm sorry, I haven't been here for a little bit. I haven't been getting the communications, but you're all representing groups of people, correct? County council's represented, right? Correct. Prosecutor's office is represented. John, could you hear me out for a second? If
Judge Russo.
When I'm having a hard time getting my arms around is why these decisions have to go back to all of the judges. With all due respect, if every time a decision has to be made, they've got to go back and meet with all of your judges. This process is going to take exponentially longer. Exponentially, and all due respect to you, John, I understand, but I'm a little confused with why this has to take place. Two major decisions in moving forward here are now stalled for at least 2 weeks until they come back and talk to all the judges and the judge. I just don't understand that. I really don't, because if that's how this is going to go, I can argue this committee's too big, but the committee's the committee. But if that's how this is going to go, this is going to take forever to get done.
We'll consider that to be public comment. I was going to ask for any other public comment, so that'll be public comment within 3 minutes. Do we? We did that. We did that. We did that. Okay. So we are about ready to adjourn the meeting. I'm going to go around the room one time. I will tell you that the next, there was an earlier schedule that it's buried in your stuff, but I'm going to tell you that the next steering committee meeting, so what's going to happen is we're going to have an interim, we're going to do this work we've talked about. We're going to have an interim report in October, and then the next major meeting that will have a lot of substance, a lot of determinations moving forward, will be November 21, November 22, 21. It's November 21. And that was on you may have lost sight of that. It was on an earlier schedule. And I'm going to go ahead. We actually have a schedule of all the steering committee dates. It was in an early document. I'll send it around to everybody again just to make sure it's on everybody's calendar. But the next meeting is September 21. November 21. Excuse me. November 21. Okay? With that in mind, I'll just... if anybody has not signed in on the sign-in sheet, please do so. By signing in on the sign-in sheet, you will have notice of following meetings. And if you want to be on the public notice list, which is getting large, but that's fine, sign in and you'll be on the public notice list for the next meeting. With that in mind, I think we've concluded our business for today. Is there any final or closing comment? And we'll just go around. Any final or...
I would like to recommend, I appreciate that the MOU says that the agenda will be sent out 5 days before. I would like to recommend that, if possible, it be farther in advance of the meeting than that.
And let me tell you, and I'll be frank about that. The issue of the agenda not getting out before that had a little bit to do with some uncertainty about how to handle the language on determinations 1 and 2. And I did go back to the lawyers who are involved. We will endeavor to make sure you have it. We never intended to wait as long as we did, quite honestly. So I will make every effort. And what we may actually do, I think what we'll do, the key part of the agenda, as we know determinations that we're going to ask for, we may not wait for a comprehensive agenda. We may send out select determinations to the committee and just, we won't call it sending out the agenda. It'll just be information, so you can get that in advance. And the other thing that we will try to do with the courts in particular, and with those who have to go back to your constituencies, we'll try to get you that enough in advance, so hopefully some of those meetings take place before this. We actually did have some meetings that we had scheduled that were canceled, not by us. So we had originally intended to do that. So, but we'll do the best we can. Other questions, comments as we go around?
Motion to adjourn.
Let me just ask if there's any other questions, comments. You can't cut this off. Any other questions, comments? Anything else you have? Is there a motion you'd like to make? Would anyone like to second that motion? All in favor, say aye. We are adjourned. Thank you very much.